Mr. Abbott's representing Davis. To, we have his fingerprints?
No.
Where's Mr. Abbott? And I'll do it. And Mr. Yang, which matter are you here for?
I'm somebody in for Mr. Armstrong. I just got the complicated this morning.
Mr. Armstrong.
Keto Armstrong.
Oh, no, the first one. I'm looking for an attorney last name. Say he was subbing in. Okay. Where's Mr. Armstrong?
He's in the courtroom, Your Honor.
Is Mr. Armstrong?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Keto William Armstrong. File number 23-01002 FY. Council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Armstrong. I will be subbing in from the Public Defender's Office as a conflict counsel. I received that request this morning and so I walked in. The sub is being signed now. It should be to the court by the end of the day today. Today's date and time set for the PCC. Some preliminary discussions lead me to believe that I would need additional time to review discovery. So I talked to Mr. Armstrong about waiving the timeline and adjourning the prelim that's scheduled for next week to a new date to give me time to get caught up.
Okay, sounds good. Mr. Armstrong, how are you?
I'm good, Your Honor.
What was the purpose of conflict counsel?
I believe one of the witnesses
Represented by public
represented by the. Yes.
Okay, Mr. Armstrong, you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned on March 27, 2023. But because the public defender's office is representing one of the witnesses in this matter, your case seems to be conflicted out. I'm not going to require you to waive your rights. I'll find good cause to go beyond the 21-day timeline, because that's really outside of your control. But it's in the best interest for you to have counsel outside of the public defender's office to represent your interests. So with that being stated, we'll go beyond the 21-day timeline and get you new dates for your exam. Do you need a new PCC?
I don't think so. I think we can accomplish that via email or phone calls, and we just need a new prelim date. I'm not sure what days your prelims are set for in the next few weeks.
It will be May 25th at 9:30. May 25th work for you?
May 25.
Yes,
What time?
9:30.
9:30. That works, Your Honor.
May 25th at 9:30. Any additional matters for the record today?
Yeah, there was a note from 30th Circuit that he had not been reported to pretrial services and they would like to get his updated contact, like for this court to get his updated contact information.
So that's all that email. This one, yeah. Phone number.
517-883-3511.
Okay, that's what's in the file, but it looks like it was transposed in the system because pretrial service has 883-3571. So we'll make sure they get your emails it back and give them the correct number. That's number one. Number two. Were you advised that you were supposed to report to pretrial services within 48 hours?
I was advised to go and report straight to my probation officer as soon as I was released. And then I was talking to my attorney, and then like yesterday, he told me I need to go report to pretrial services. And then I contacted him yesterday.
Yeah, it states here that you were advised to report to pretrial services within 48 hours. Were you in custody when you were arraigned?
Yes, Your Honor.
Okay, well, then you should have received the slip, but they will get your updated number. I can see why it was transposed. It looks like the handwriting probably was a little bit too close. So it looks like a 7, but I can tell it's a 1. All right, nonetheless, we'll make sure they have the updated contact information. However, you need to make sure you remain in contact with them, and you need to get the number to contact them. You're going to contact them today, okay?
Yes, Your Honor.
That's the number that you need to contact. Do you have any questions?
No, Your Honor.
Okay, any additional matters for the record? counsel?
Nothing from the field. Thank you, Your Honor.
Nothing further from the defense, Your Honor. Thank you.
Okay, we'll see you on May 21st. I'm sorry, May 25th. Mr. Abbott. Good morning. I see that you're continuing on Larry Funches.
Yes, Your Honor, yes, we are.
He's what?
We're leaving it out for preliminary exam.
Okay. Is he here?
He was on Zoom.
Where is he? You told him about he has a PA 53 violation. Yes, it's clearly a
told him to
violation.
stay.
Huh?
That's why we told him to stay.
Do you have his contact information? Do you have him log on? Because he needs to be arraigned, and so we could handle that PA 53 at the same time of his exam, if we can get him arraigned today.
Yes, Your Honor.
Okay, that's Funches, and then you have Decker. He's in custody.
Decker is not in custody.
My records reflect he is.
So did mine, Your Honor, but he just got out.
Okay. Davis, you're representing Davis?
Yes,
Okay, we need Mr. Davis's fingerprints.
okay.
Mr. Davis, can you hear us?
Yes, Your Honor, I can.
Very good. We're on the record in the matter of the people of the state of Michigan versus Anthony Davis, file number 23-00817, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott representing Anthony Davis today.
Okay, Mr. Davis, I don't know if you heard me, but we need your fingerprints.
Yes, Your Honor, I understand.
Okay, let's see, we're currently scheduled for preliminary examination on April 13th at 9 o'clock in the morning. Are we continuing to exam?
At this time, we are, Your Honor.
Yes, we are, Your Honor. He was in custody and he got bonded out as I was actually arriving at the jail, so missed him. In addition, he's got another case that's set for probable cause conference on the 14th, 21-3352 FY. So I'm hoping that we'll be able to consolidate the solution to both those problems.
Who's that set for before?
You.
Oh. Okay, so Mr. Davis, you're gonna be here in person next week. You can get your fingerprints done then while you're here, okay? You know,
Yes, Your Honor.
early so that you can still be on time for your 9 o'clock appointment here, okay?
Yes, Your Honor.
Any additional matters for the record today?
Nothing back to people. Thank you, Your Honor.
Nothing from the defense. Thank you.
Thank you. You're all set, Mr. Davis.
All right, thank you.
You call Larry Funches. Okay.
Yes, please. Thank you.
Thank you, Your Honor.
Mr. Dillon, which matter are you here for?
Thank you. I've got People versus Ricky Evans. I'm substituting in.
Oh, okay. And are we running that one or is there a request to adjourn? Is that
I'm
what-
asking for a couple weeks around. I just was retained.
Sounds good.
Recording you.
We're on the record in the matter of the people of the state of Michigan versus Ricky Evans, file number 23-00897, council appearance.
Brian Ring on behalf of the people.
Lucas Dillon on behalf of Ricky Evans. Ricky is standing to my right.
Okay, Mr. Evans. Doing well. Today was the date and time that was set for a preliminary examination. You have recently retained Mr. Dillon. Substitution counsel, correct?
Yes, I just texted my office and had them email it over to Mr. Austin. Ricky is gonna have to sign that today and then we'll get it to the court.
Okay, and Mr. Evans, you understand that you have the right to have a preliminary examination within 21 days of your arraignment?
Yes.
You were arraigned back on March 18th, which is why your exam was set for today. But due to your substituting to new counsel, are you willing to waive the 21 days so that we can give you a new court date?
Yes.
Okay, nobody's threatening you to do that?
No.
May 25th. Does May 25th work for you?
Yes.
Okay, at 8:30. May 25th at 8:30, we'll get you a copy of your notice to appear. Do you have any questions today? Okay, any additional matters for the record, counsel?
Your Honor, there was an offer. I will just go ahead and place it on the record while we're here. The offer was to plead to an attempt, resisting and obstructing, and the people would consent to HYTA.
We just asked if that's preserved. And was that court date, Your Honor, set as a PE or PCC?
PE, but did you need a new PCC?
No, I think that's fine. I'll be in contact with the prosecutor before then.
Sounds good. We're all set on that then. Thank you.
Thank you, Your Honor.
Okay. On the record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747, counsel appearance.
Brian Ring on behalf of the people.
Somebody represent me.
I'm sorry?
I didn't understand how somebody represent me and I'm representing myself.
No
And
one
I
has-
can't see
no one said
myself
that they were
on Zoom.
Nobody said they were representing you.
Oh, I thought that's
He
what
said-
you just.
He
I
said
thought that's.
he was here on behalf of the people.
Oh, okay, my fault. I'm sorry, Your Honor.
Okay. You wish to represent yourself, sir?
Yes, ma'am.
Okay, and why
I
is
can't
that?
see myself on the screen.
Okay. Are you under the influence of anything at this time?
No, ma'am.
Okay. I don't know why you can't see yourself on the screen.
I could just hear me and see you. But that's
Are
okay.
you-
That's okay. That's okay.
Okay. Okay, so you understand, sir, that you do have the right to have court-appointed counsel represented at the expense of the public if you cannot afford to hire an attorney?
Yeah. Yes.
Okay, and you wish to waive that, you say?
Yes, ma'am. Oh,
You know what,
one more
Mr.
other
Edwards, you
thing,
need to
ma'am.
appear in person. You need to appear in person today, okay?
How was I supposed to appear in person? I live in East Point, Michigan. That's down there by Detroit. I've been served a summons felony and not a complaint felony. I don't know what's going on, ma'am, and I want to avert the jurisdiction and read my warrant into record.
Okay.
I
well,
don't
you
know
need to do
what's
that in
going
the
on, man,
courtroom,
and I
okay?
know, and I understand this Zoom is illegal according to Tyler versus Illinois, 48-4 US 400. I know it is. So I know I have to report, but you're gonna have to give me some time because I don't have transportation.
Okay, when are you gonna get here?
You're gonna have to at least give me a month. You're gonna have to at least.
No, you're not getting a month.
I
You got a court date on the 13th.
I can't make it. I can't
Oh,
make it.
okay, well, then you'll get a warrant, okay?
I'm asking the court
If you don't
to
appear on
adjourn
the
it until
13th, you'll have a warrant for your arrest. We're not giving you a month to show up to court.
Ma'am, I'm asking the
Do
court
you have
to
any
adjourn.
questions at this time?
Yes.
What's your question, sir? I'm happy to answer them, but what I won't do is go back and forth with you about nonsense, okay?
Okay, yes. All right. I have a corn warrant. May I read it into record?
I'm sorry, you have what?
I have a warrant. It's QUO warrant. And I have a lack of jurisdiction and a motion to
Oh,
dismiss.
okay, gotcha. Yeah, you need to file that with the court and serve it on the prosecutor. We're not reading that on the record today, okay?
We can't read it. All right. Well, since
No,
we
no, you
can't
need to
read it
file
on
it
the
with the
record,
court. You need to do
I-
you need to do an appropriate filing and then you serve the prosecutor, okay?
I will, ma'am. But I have one more other thing. Since this is probable cause, can you at least let me know what my charges is and who is lodging the charges against?
Yeah, did you appear for your arraignment on March 8th?
Yes, I did, ma'am. And they put me on a
Okay, and were
personal
you advised
bond.
at the time of what you were being charged with?
She said something about larceny, but she didn't say from who.
It's exactly what you're being charged with, a larceny.
Yeah, right, but she didn't say from who.
You're being charged by the people of the state of Michigan for count one on or about August 19, 2022 through August 20th, 2022 at the area of 4600 Collins Road, City of Lansing, Ingham County, State of Michigan, for allegedly committing the act in count one of larceny, $1,000 or more, but less than $20,000. It alleges that you did commit the offense of larceny by stealing money that belonged to a Avonshire. The value of the property stolen $1,000 or more, but less than $20,000. This was contrary to Michigan Compile Law 750.356(3)A. That's a felony. Maximum penalty 5 years and/or $10,000 in fines, or 3 times the value of the stolen property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. There's an habitual offender, 4th offense notice. So that would enhance the maximum penalty on this. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 11, 2016, he was convicted of the offense of failure to return rented property, $1,000 to $20,000 in violation of MCL 750.36583A in the 16th Circuit Court of Macomb County. And that on or about March 7th, 1997, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.74012A4 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.224 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of felon in possession in violation of MCL 750.224F in the 4th Circuit Court of Jackson County. And that on or about February 5th, 1993, he was convicted of delivering, manufacturing less than 50 grams in violation of MCL 333.74012A in the 31st Circuit Court of St. Clair County. And that on or about March 14th, 1991, he was convicted of the offense of delivering and manufacturing less than 50 grams in violation of MCL 333.74012A in the 4th Circuit of Jackson County. And that on or about August 5th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams and contrary to MCL 333.74012A in the 31st Circuit Court, St. Clair. And that therefore, the penalties are a maximum of life if the primary offense was 5 years or more, or 15 years or less if the primary offense has a penalty of under 5 years. This is again a larceny with the maximum penalty of 5 years. So you are facing life as a maximum penalty. I ask you again, do you want court-appointed counsel?
Okay, ma'am. I wanna interject that the MCR 404B1 said you have to show conformity to the habitual, and there's no conformity, and is over 10
This is a
years
probable
old.
cause conference. We don't have to
It's
show any
over 10 years
conformity at a
old, ma'am.
probable cause conference. So this is what we're gonna do. We're gonna see you in person next week, okay, sir?
I can't make it
Well, if you don't make it, guess what's gonna happen? A bench warrant will issue. You go ahead and have a good day. I got other cases to handle.
Can I call up my witnesses for next week? Or do you want to?
You absolutely can.
Thank you.
Okay.
He's a sauce.
As under the influence of something as well. It's Robertson. Okay.
Oh, she was just reading off his habitual offender charges and telling him that it was a life offense. Asking against people's counsel.
Can I go speak with the victim out there?
You may.
How do I pay it?
Oh, no second.
On the iPhone.
Yep, this is Brandon Decker.
Okay, Mr. Decker, let's see, that's Mr. Abbott's. Find your attorney. Hold on, I'm gonna put you on mute until we find him. Oh. Need to get you public defender some pagers. Is Abbott on the record in board? He has Mr. Decker here. I think I spelled his name wrong. Mr. Abbott.
Good morning, Your Honor.
Good morning. Did you need to speak to Decker at all?
I have not been able to contact him yet.
Mr. Decker is here.
Oh,
I was asking if you needed to speak to him. We can get you on Zoom.
Hello? Hello?
Hello, what's your name? Can you hear me?
Me?
Yes. What's your name?
Yeah. Oh, Chris Fairley? I was just testing my connection. I got a court date at 10. I didn't know it was gonna put me like right in there. I was just making sure
Oh,
everything
yeah,
worked.
it puts you right in here. You said your name is what?
Chris Fairley?
You have a case number, sir?
1802193 GCE.
That's definitely not today. Yeah, I just pulled out my yesterday's docket. You're a day late.
No, I
You
say
were supposed to-
Thursday.
You
It say
you were
my
supposed to
paper,
be here yesterday at 8:30 in the morning.
my paperwork. Can I turn my camera around and show you the paperwork? It say April 6, 2023 at 10 a.m. Is there any way to flip the camera on this?
You could flip the camera. I don't know what you're on though.
I'm gonna show you my paperwork
Yeah,
from the mail.
we gave the file back already, right?
This is my paperwork.
my document yesterday.
No, this is my paperwork in the mail.
It
This is
was
what I got from the
February
court, a court
6th,
subpoena.
but it was rescheduled. Who rescheduled it? Me, so you should have gotten another. When? Because it would have been on this date.
This is what the paper say in the mail.
Okay, yep, that was the first date that you got, sir. And then it looks like it was rescheduled and you should have gotten a new date. Why was it rescheduled?
I ain't getting no new date. This the only paper I got.
What happened yesterday? No, what happened on the case? Oh, different thoughts with the show. Okay, reset it. Okay, we're gonna reset it because it looks like that the date you got in the mail was already reset. You should have received the date a month ago. So when you didn't appear yesterday, the attorney asked to set it for a show cause hearing. So what we'll do is reset it and give you the date right now. Then we'll send you another one in the mail. Do we have, what's your address?
4414 Barclay.
You don't have the right address. That's part of the issue. We don't have the correct address for you.
14 Barclay Place.
4414 Barclay.
Yeah, I just moved there though. Like I just moved there.
Okay, yep, and then you need to, you always have to advise the court when you update your court dates or your address so that you can get your court dates in the mail. Because you're responsible if you don't get it. You know that, right?
Yeah.
Okay, we're gonna reset this. Reset it for April 18th. That's April 18th at 2 p.m.
Okay.
It was Mr. Smith, right?
So what happened yesterday? Like they say I didn't show up. Well, I didn't show up
because it's a civil matter. Yeah, it was a civil matter, and it was your first failure to appear for a creditor's exam. So what happens is that the attorney requests to have a show cause, meaning we set it for a hearing for you to appear and tell us why you didn't appear.
Okay.
So you appeared today. We're gonna get it reset. We just told you the date. That's April 18th at 2 p.m. We'll send to the address of 4414 Barclay a notice to appear. Okay.
All right.
Do you have any questions?
Yeah. They were saying something about a 601, the original contract, because when I talked to them, we had the
Oh, no. We're not gonna get into the case right now. I just want to know if you have any questions about your appearance at this time. I don't even have your file before me, and I need the other attorney here before we can get into the facts of that case, okay?
All right.
So do you have any questions about your appearance between now and the 18th?
Nope. April 18th at 2 p.m.
At 2 p.m. and you'll log in the same way you did today.
Under the same number?
That's correct.
All right, thank you.
Thank you.
Yep.
I don't know who's on this Motorola. Okay. You've already spoke to Mr. Decker, but we don't have a prosecutor at this time.
Your Honor, the prosecutor has recently transmitted an offer, which I have yet to discuss with Mr. Decker. He also needs to receive the police report. It's in the mail. So I'd like to leave it on the schedule.
Okay, sounds good. Okay, we'll continue to examine. Do you want me to release Mr. Decker at this time?
Thank you.
Mr. Decker? Just be doing all kinds of stuff while they're in virtual court. Mr. Decker, can you unmute, please?
Sorry about that.
Okay, your attorney is here, and he says that you're gonna continue to examine at this time, that there's been an offer that has been extended to you, but then also, discovery still needs to be reviewed with you, okay?
Yes, ma'am.
Okay, do you have any questions?
No, ma'am.
Okay, well then we'll see you next week in person.
The next week in person.
That's correct.
All right. Yes, ma'am. Thank you. Have a good day.
Same to you.
No.
You know where Mr. Ring went?
Right around the corner. So I'm just gonna pick them. Just get ready.
Let's see, there is here. We're just gonna wait. He's not
Zach
in the room,
Taylor.
he's in the hallway.
Did he get his fingerprints?
No.
Well, if he's gonna do that, break and wave.
He's got.
I don't care. They have to do it each trial. They take that so seriously.
Right.
I don't know why. Fingerprints could change, I guess. Or maybe that's how they confirm who you are. I don't know. Okay, we just need Mr. Ring to return to the court.
We are. Sorry, there was another incident in the hallway where I had alerted security that there was a defendant sitting down there and some weird man sitting beside her and she looked very uncomfortable. So I alerted security to that. All right.
Okay, we're on the record in the matter of the people of the state of Michigan versus Brett Karatny, file number 23-009, I'm sorry, 399 FY, appearance for the record.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Karatny. He appears with us today remotely from the Ingham County Jail.
Okay, Mr. Karatny, how are you?
I'm good, Your Honor. Yourself?
I could barely hear you.
I don't know what I can do.
What's going on? Something must be going on in the jail. It's really low. You can hear me clearly?
Yes, ma'am.
Okay, and so you're still seeking to hire your own counsel?
Yes, Your Honor.
Okay, so you understand, sir, that you have the right to have a preliminary examination in this matter within 21 days of your arraignment?
Yes, Your Honor.
And you understand that your request to hire your own attorney and have them substituted for the public defender's office would mean that you would need to waive your right to have that exam within 21 days. You understand that?
Yes, Your Honor. I'll waive that.
Okay, anybody threatening you to get you to waive the 21-day timeline?
No, ma'am.
We'll set it for 2 weeks out.
Your Honor,
Yes, sir.
you said the other, I don't know if you remember, Monday we had court and you set my other one for May 1st. Can we get it roughly the same time?
Oh, you want to have it on the same day as your other court date or around the same time?
For the same week, Your Honor, he was just asking for as much time as the court would allow. It's difficult with him in there. He's relying on other people to help him retain Mr. Carter. So his misdemeanor case is set for May 1st, and I think he was looking for something in the same week. The court would grant him
Sounds
that
good.
much time. With the same claim.
On May 11th at 9. May 11th at 9.
Sounds good.
Okay, do you have any questions today?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further on behalf of Mr. Karatny, Your Honor. Thank you.
You're all set, Mr. Karatny. Thank you.
Thank you, ma'am.
You're welcome. Mr. Lyons?
Morning.
Morning, how are you?
Just fine.
You have David Johnson with you?
I do, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus David Johnson, file number 23-00821 FY. Appearances for the record.
Brian Ring on behalf of the people.
And please the court, George Lyons on behalf of Mr. Johnson.
Okay, we need Mr. Johnson's fingerprints.
Your Honor, I will send him down to Lansing PD to have that done. Too sweet.
Thank you very much. Today was the date and time set for probable cause conference. This matter is scheduled for preliminary examination April 13th at 9:30 in the morning. Are we continuing to examination on that date?
Ronald, I'm assuming, given his age and the fact that he has no prior convictions, that he is HYTA eligible. We're going to waive the preliminary examination with that in mind. He understands his right to have the preliminary examination and does in fact waive that knowingly.
Sounds good, Judge. If people would unconditionally waive their right to preliminary examination today as well.
Okay, was there an offer at all?
There was no offer, Your Honor.
Okay, Mr. Johnson? Can you hear me, Mr. Johnson?
Yes, ma'am.
Okay, you understand, sir, that you have a right to have a preliminary examination in this matter here in the district court?
Yes, ma'am.
You understand that at the time of your examination, you have the right to have the prosecution meet their burden, which is to establish they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
You wish to voluntarily waive your right to preliminary examination today?
Yes, ma'am.
Has anybody made any threats to you to get you to waive your exam?
Yes, ma'am. Oh, no, ma'am.
Who threatened you? Is Mr. Lyons threatening you? Blink
Oh, ma'am.
twice.
I'm sorry.
No, Your Honor,
Okay.
he's my nephew, so he knows better.
Oh, he's gonna be threatened. No, I'm just playing. Okay, and so no one's threatening you, sir?
No, ma'am.
Any promises being made to you in exchange for you waiving your exam?
No, ma'am.
Okay. Your bind over date is gonna be April 19th. You do not need to appear in court on April 19th. That's the date the circuit court gets the file from this court, okay?
No.
I find that your waiver was made freely and voluntarily. Bond was set in this matter at $100 personal recognizance. That will continue. And let's see. Confirm his address and phone number. Are you still at the address on Trappers Cove?
No.
No?
Yes, ma'am.
What's your address?
248 Kathy Circle.
Did you catch that? You did that? Yeah, I got it. But it's not in here. Got it.
I think there may be
Phone
some
number is the
confusion.
number.
Your Honor,
I'm
there may
sorry?
be some confusion. He does not stay at Trappers Cove anymore. He's at 248 Kathy Circle in Jackson, Michigan.
Okay, yep, we want to make sure we have an accurate address so he gets his court dates.
Thank you.
Okay, very good. Okay, so your next court date will be a pretrial in circuit court. Do you have any questions for the court at this time, Mr. Johnson?
No, ma'am.
Any additional matters for the record, counsel?
Nothing about
That's
it.
not,
Thank you,
Your Honor.
Your
You guys have a great day.
Same to you. Are we running?
Your Honor, I'm gonna ask for it. I'm gonna ask for it.
On the record in the matter of the people of the state of Michigan versus Timothy Franklin Hart, file number 23-00900, counsel here.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Hart. He stands present to my right.
How are you, Mr. Hart?
Pretty good. Would have been nicer if that warm weather would have stuck around. Yes.
I think I would agree with that for sure, but it'll be back, I think next week. Okay, today was the date and time set for preliminary examination, and there's a request to adjourn.
That is correct, Your Honor. I didn't have a good contact for the victim. She did show up today. I was able to speak with her just very briefly. There is some evidence that I wish to go over with her, so I would ask for an adjournment for time to go over that with her and then to formulate some potential offer for Mr. Austin.
Mr. Austin.
Yeah, thank you, Your Honor. I am not opposing that request for an adjournment. There was some additional evidence that came in that Mr. Ring alluded to. It is rather quite voluminous, and I've discussed this with Mr. Hart. My understanding from that discussion is that he is in agreement with the adjournment. I think it may very well aid in resolving this case, so I think it would be in his best interest to do so. He does understand he's entitled to have this hearing with 21 days of arraignment, which is set for today. And he also understands that if the court grants the adjournment, it won't happen within that time frame. He's not waiving or giving up the right to have the hearing, just the timeliness of it.
Okay. You have any questions about those rights, sir? Okay, and nobody's forcing you or threatening you to waive the 21 days today?
No, Your Honor.
Okay. Get your new date. May 25th at 9:30. May 25th at 9:30. We'll get you a copy of your notice to appear. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further on behalf of Mr. Hart, Your Honor. Thank you.
Thank you. You're all set, sir. Thank you.
Thank you.
Thank you, Judge.
No problem. Oh. Where's Miss Alvarado's signature? Is Kelsey Alvarado present today? No.
Yet to see her.
Who's who? They said to leave on for exam. Oh, well, I'm not signing that. If she does have to sign it, I don't have to sign it either. We'll ask for her signature. Benito Valles, we're running that.
Mr. Sarch just went down to go talk to him again, Judge. That's still up in the air.
Sounds good. Who do we have back here? Sir, what's your name?
Mr. Saylor.
Mr. Saylor.
Zachary.
Okay, did you get your fingerprints?
Yes, ma'am.
Very good.
That's Mr. Abbott's. I'm gonna go check and see if I have any officers that I can let go, Judge. Is that all right?
Sounds good.
Jacob, can you hear me?
Not playing it.
Hey, Jacob, can you hear me now?
Yeah.
You're sideways. Can you flip your phone over a little bit?
Just do it like this.
There you go. Yes, sir. Perfect. Hey, it's your attorney, Steve Cornish. We're doing a waiver today. Is that correct?
Waiver. I thought it was a pre-trial or something like that.
No, we were doing the waiver of the prelim. We talked about it last night.
Yeah, you're right. Yeah.
Okay, I'm gonna go ahead and sign that form then. They'll put you on the record as soon as the judge is ready, okay?
Okay.
Right. And we talked about, no takebacks and all that stuff like that. You're good to go.
Yeah, I'm good to go.
All right.
No protection of nothing. Mom, stop.
You're unmuted.
Court. You gonna do this while I'm in court?
Why don't you mute yourself till we're ready to go, okay?
Yeah.
Okay. On the record in the matter of the people of the state of Michigan versus Larry Funches, file number 19-03012. Council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Attorney John Abbott, representing Mr. Funches. He appears by video today.
Okay, Mr. Funches, can you hear me?
Yes, I can, ma'am.
Okay, Mr. Funches, today was the date that was set for your probable cause conference. My understanding is that you are going to continue to your preliminary examination next week. That's correct?
Correct.
Okay, I also have here a notice of a PA 53 violation that's also known as a bond violation. The allegation is that on or about March 30th, 2023 at 9:00 p.m. at the area of 824 Lapeer Street, City of Lansing, Union County, State of Michigan, that you allegedly violated the terms of your bond conditions by making third-party communication with a Michelle Geary in violation of your bond conditions. And so you have the right to have a contested hearing. You have the right to be represented by your attorney at the time of your contested hearing. If you are found to be in violation of your bond can be revoked, and you can be sitting in jail pending this DV third prosecution, but you also can be faced with a contempt of court. Contempt of court is punishable with the maximum penalty of 93 days in jail and or up to $7,000 in fines. You understand that?
Yes, I do.
Is he pleading not guilty?
We're pleading not guilty.
Okay, so I'll enter a plea of not guilty as to the bond violation, and we will set this for a hearing at the same time as your preliminary examination, okay?
All right.
Do you have any questions?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing from the defense. Thank you.
Thank you, you're all set.
Thank you.
No problem. Sir, what's your name? Miss, nope,
George.
that's what I thought. You're supposed to be here yesterday. Let me see your notice. The schedule had to be changed because I had to add exams for today. I would have sent out notice. So he did have a notice for today. So like the same guy, like the other guy. Gotcha. He did have a notice since today. She said she had to reset because we're closed tomorrow, I think. Let me see. So he does have a notice for today? Huh? This is not the notice from here today. This was originally set for today. What's his name? You need file number 23. -00109 GCE. Yes. When did you send the notice out to me? Same date, 3/17. You sent it at what? 3/17, when they told me to change the document. Okay, me that file. I'm gonna have to set aside the default and reset it. Okay. Who's ready? Mr. Cornish has been here for a while. Mr. Cornish, what are you here on?
Mr. Kendall's waiver, he's on Zoom.
Okay, you're on the record and he is here. You're on the record in the matter of the people of the state of Michigan versus Jacob Kendall. File number 23-009666FY, Council Appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Kendall, who is appearing via Zoom.
Mr. Kendall, can you unmute, please?
You hear me?
I can hear you.
Okay.
There you go. Okay, today's the date and time that was set for a preliminary examination. My understanding is that the parties are unconditionally waiving the exam today. Is that correct, Mr. Reed?
That is correct, Your Honor.
Mr. Cornish?
Yes, Your Honor.
Is that an offer?
There is, Your Honor. The offer was to plead to an added count. Would that be? Hang on, sorry. I lost it. An added count 4 of larceny from a person. The people were dismissed the balance.
Okay, Mr. Kendall, you understand that you have the right to have a preliminary examination in this file?
Yes.
Understand that the purpose of the examination is for the prosecution to put forth evidence to establish that there was probable cause that a crime was committed and probable cause that exists to charge you with the crime.
Yes.
Do you wish to voluntarily waive that right today?
Yes.
Okay, you understand that the waiver is unconditional and you can't return back to the district court once this matter is bound over to the circuit court?
Yes.
Okay, anybody threatening you or making any promises to you to get you to waive your exam?
No.
Okay, your bind over day is gonna be April 19th. You do not need to appear in court on April 19th. That's the date that the circuit court will get the file from this court. Your next court date will be a pre-trial in circuit court. Both you and Mr. Cornish will be made aware of that, okay?
Okay.
Do you have any questions?
No, ma'am.
Okay, bond was set at 25,000, 10% with GPS tether and victim notification. There's also a curfew from 10 p.m. to 7 a.m. unless working or attending high school. Any reason to address bond at this time?
Nothing from the defense, Your Honor. Thank you.
Bond will continue. You're all set, Mr. Kendall. Good luck to you.
Okay, thank you.
Thank you, Your Honor.
You're welcome. For the record, in the matter of the people of the state of Michigan versus Mark Body the second. File number 23-00935 FY, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Bodie, stands present to my right.
Mr. Bodie, how are you, Mr. Bodie?
Great, thank you.
Okay, today is the date and the time that was set for a preliminary examination. However, I have a plea sheet here. It says the people are offering for you to plead guilty to an added count 3 of attempted resist and obstruct pose under MCL 750.81D1A. That's a misdemeanor. Maximum penalty is 1 year and or $1,000 in fines. The people will dismiss count 1 and count 2. And there's a Killebrew agreement of no upfront jail. Is that what you understand your plea offer to be?
Yes, Your Honor.
Do you want to accept that offer today?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Thank you. You can put your hand down. I have an advice of rights of key information sheet. It has today's date on it, and there's a signature affixed to the bottom. Is that your signature?
Yes, Your Honor.
Okay, did you read this document before you signed it?
Yes, Your Honor.
Do you understand all the rights listed here?
Yes, Your Honor.
Do you have any questions about any of these rights?
No.
You understand that in order to enter a guilty plea, you would have to give up each of the rights listed there?
Yes, Your Honor.
Okay, are you nervous?
Yes, Your Honor.
Okay, that's normal. Okay, you have the right, sir, to proceed to a trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you are innocent until the prosecution can prove you guilty. You have the right to have them prove each element of the charges being brought against you beyond a reasonable doubt before you are considered guilty. Do you understand that?
Yes, Your Honor.
And you're willing to give up those rights?
Yes, Your Honor.
That means you're gonna give up your right to remain silent at trial and not have silence be used against you. You're gonna give up your right to see, hear, or question any of the witnesses the prosecution intends to call at a trial. You're gonna give up your right to call your own witnesses or present evidence that you believe would further a defense. Please give me some cleanup to the charge. You understand that?
Yes, Your Honor.
Okay. And you're willing to waive those rights?
Yes, Your Honor.
Has there been any threats made to you to get you to want to waive your rights? Or any promises being made to you for you to waive your rights?
No, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
Okay, I understand that a guilty plea could result in a conviction that you may need to report to your employer.
Yes, Your Honor.
You understand that a guilty plea could result in a conviction that may have a status or effect on status under immigration, or if you want to travel, it could affect your ability to travel to certain countries. You understand that?
Yes, Your Honor.
Okay, you still want to give us your rights, understanding that?
Yes.
Are you entering a plea because you believe you are guilty?
Yes, Your Honor.
Are you sure? I saw you contemplating that. If you're not sure, you should not waive your rights. And you can have more time. I can set
I
this out.
believe a guilty plea is the best plan of action to move forward.
That wasn't the question I asked you.
It was not, but it's the answer that I'm prepared to.
Yeah, okay, well, then the plea is not accepted. Well, we'll continue to another date. That'll give you more time to think about it, because you don't get to give me the answers to the questions you want. You have to answer my questions. They're carefully crafted to make sure you're not waiving rights just to get something over with.
No, Your Honor, I understand my charges and I know I did them.
Okay, so you are entering a guilty plea because you believe you're guilty.
Yes.
Okay. Actual base, as to the added count of attempted resist and obstruct and oppose an officer, how do you plead?
Guilty.
Factual basis.
Mr. Bodie, I want to take you back to March the 20th of this year, 2023. It's true you were at or near the location of 5910 South Pennsylvania and Lansing, Michigan.
Yes, sir.
Is that here in Ingham County?
Yes, sir. I'll tell you the truth, I really don't know if it's Ingham or Eaton, but
Okay.
Yes, sir.
If the information in the report indicated that it was Ingham County, would you have any reason to dispute or disagree with that?
No.
Okay. And that was an establishment that was open for business that you were at, is that correct?
Yes, sir.
And the police responded to that address because the business was attempting to remove and trespass you from that business, is that correct?
Yes, sir.
And the police, in order to effectuate that trespass, asked you to identify yourself by identification, is that correct?
Yes, sir.
And is it true that you failed to comply with those requests from them?
Yes, sir.
And you recognize that they were police officers because they were in police uniform?
Yes. Yes, sir.
Satisfactory, Your Honor?
Any questions from the prosecution?
No, thank you, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. There's a Killebrew agreement. That's an agreement between you and the prosecution. I'm not a party to that. So if I'm going to determine that I would sentence you to a term of jail time, I would give you the right then to withdraw your plea, okay?
Yes.
Any objection to immediate sentencing?
No objection for the people. Thank you. Your Honor.
I'm not opposed to that, Your Honor. Thank you.
I'm gonna get this going on the street. Just a minute. You can make allocution.
Yes, thank you, Your Honor. I know when I looked at Mr. Bodie's iChat, it appears that he does not have any prior felony convictions. His criminal history seems to consist of mainly nonviolent property or controlled substance offenses. It appears that the last time he was convicted of anything was approximately 11 years ago. He has a young child, and I know he's in between jobs right now, Your Honor, but he does have a lot of experience. I know in the restaurant, food service industry. I think this particular incident, Your Honor, Mr. Bodie was under a stressful period of time. And from what I can tell, Your Honor, I think this appears to be something out of character for him. Mr. Bodie also has an upcoming surgery in approximately 1 month. Some major foot surgery. It's probably going to lay him up for a considerable amount of time. I would just ask the court to take that into consideration, Your Honor, and I would ask the court to abide by the Killebrew agreement and not impose any incarceration on Mr. Bodie.
Mr. Bodie to make his own statement today.
Yeah, man, I got in a lot of trouble when I was younger. I've really been trying to clean my life for 10, 11 years. I got a son, he's 9 years old. I just got fired because I got arrested and missed a 12-hour shift, but I was assistant manager for a year. 2 weeks, I got fired, but it would have been a year, but 2 weeks. I got my business degree 6 years ago, and I just can't find a sit-down job because I need so many surgeries. I've got to sit down. But yeah, he hasn't said anything that's not true. I just was really stressed that day and wanted a relief. Didn't want to talk to people. I messed up.
Thank you for that. I reviewing your prior criminal history. I see only one violent conviction. But again, it was from over 10 years ago. In that particular instance, you were charged with a assaulting an officer, but that one was dismissed. And I don't see where you had any interaction. I recognize you're going through probably a challenging transition in your life, and even from the time that I've been taking this plea today, you've been very emotional. So that indicates to me you've got something going on, sir, and you need to get some help to address that. And I don't know what that is. I'm not going to investigate that. That's not my job at this point. You're 39 years old.
I will be in September, yes.
Okay, you're a 38, 39-year-old man with a criminal history and obviously with some physical challenges, and then now with some employment issues. And so that you see how that mounts the issues.
Yes.
It's only going to make things worse. But at your age, you should have developed some skills that would help you when you're in challenging circumstances so that you don't react in a way that puts you before the court for resisting an officer. Something as simple as an interaction like that you could have avoided being here.
I understand.
And you can't let your emotional state dictate how you react. You have to be in control. If you don't learn that at this age, you'll never learn. You've got to make that choice that I'm going to be in control of my actions. I'm not going to let what I'm dealing with control how I react. I'm going to be in control. Because you just made whatever you was dealing with, whatever you was out trying to get a release, you just made it worse. You see how that happens?
Yeah, I definitely was mistaken.
I think that you're serving your sentence to be frank, because you lost your job because you were arrested over this situation. And then now you're in a situation where you're going to have surgery. As you stated, you need a sit-down job, but now you got an extra conviction and a surgery. I don't know how that'll impact your ability. You're definitely employable. It's just finding the right employer. You work on that, you focus on that, and you focus on your mental health and your emotional health, okay? Because you've got a lot going on, and I think it's reasonable that you're emotional, but you need to do something to address it so that you can be stable, okay, sir? And that you won't be back before the court. You had a nice run where you weren't here. Let's get back there and keep it there, okay?
Yes.
As to fines and costs, a $75 crime victim rights fee plus a $50 state minimum cost that by statute must be assessed. That's $125. When can you make payment?
Honestly, in August, I have $100 right now, and I have surgery in 3 weeks, and I won't be able to work until the earliest July 4th with 8 weeks of therapy requested. But like, if I'm feeling good, I can go back to work. But if not, then I need therapy. So earliest August, because I gotta have some time to make money because my therapy gives me till July, but I gotta have some time to make money. So the earliest August.
How are you gonna remember that you have to pay this in August if it's April?
Oh, lots of reminders, and Siri never forgets.
Oh, you know about Siri, huh? So you can say, hey Siri, remind me to pay my fines and costs.
Yes, ma'am.
August
Yes, Your Honor.
1st.
Yeah. My bank account, everything's connected. Yes, Your Honor. This is life. And I made it that point for 10 years. Like I said, because I had to change. I had a son, and then I couldn't just be young and dumb anymore. And
Remember that when you have an interaction with an officer, it's not a decision about you at this moment. It's a decision about your family and their livelihood.
Yeah, I was, yes.
I'll give you till August to make the payment. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on that, Mr. Bodie, Your Honor. Thank you.
Good luck to you, sir.
Thank you.
Mr. Abbott's hiding. I never know he's over there.
I tried to get him in right here before Mr. Austin, but
He was hiding. I didn't see him. You're here for Sailor, Mr. Abbott?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Zachary James Sailor, file number 23-00744, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Sailor. He is present and standing to my right.
How are you, Mr. Sailor?
Good, how are you?
I'm doing well, thank you. A date and the time that was set for a preliminary examination. How are we proceeding?
At this time, I spoke with Mr. Abbott, and the people are on condition within their right to preliminary examination.
As we are as well, Your Honor, we'll leave preliminary exam.
Any offers?
There was no offer to be placed on the record this time for continuing negotiations with circuit court. Your Honor.
Okay. Okay, and Mr. Sailor, you understand that you have the right to have a preliminary examination in this file?
Yes, ma'am.
You understand that at the time of the preliminary examination, you have the right to have the prosecution put forth sufficient evidence to establish that a crime was committed and sufficient evidence to charge you with the crime.
Yes, Your Honor.
You want to waive that examination?
Yes, Your Honor.
You want to waive it freely and voluntarily?
Yes, Your Honor.
Is anybody threatening you?
No, Your Honor.
Is this your signature here, sir?
Yes, Your Honor.
The bind over date is April 19th, 2023, at a time to be determined by the circuit court. You do not need to appear in court on that date. That's the date they get the file from this court, okay?
Yes, Your Honor.
Your next court date will be a pretrial in circuit court. Both you and Mr. Abbott will be made aware of that. What's your address
216 South Dunbar,
and your phone number?
517-703-7620.
Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing to the defense. Thank you.
You're all set.
Thank you. See you, John.
Give Mr. Runciman a new date. You give it to her?
I was asking for the.
What's that? Oh, I see it. You're all set for now, Mr. Runciman. We'll see you on April 20th. We have to reset your matter because the other parties appeared yesterday. They got their new notice. You did not appear. So there was.
I know why it was, it was on the cell phones, my mistake, I apologize.
Correct, but I'm gonna set aside the default and reset it, okay?
Okay.
So you got your new notice?
The date, the 20th
Correct.
of April.
Yep. We'll see you then.
Do I have to do anything else?
Not today.
I have an attorney.
If you have an attorney, it would be helpful. They have an attorney, the other side.
Yeah. Can I get assistance for, low income?
Not for a civil matter.
Not for civil, just to bring civil.
That's, yeah, you only can get an assistance of counsel in a criminal.
Yeah.
Okay?
I had one before.
Might want to try legal aid, sir. You might want to try legal aid.
Legal aid?
Legal aid, yeah. It's not something the court can appoint for you, but there are agencies out there that can help. Okay? Or the state bar, they have a pro bono program.
Thank you.
Thank you. Okay, let's see, who are we missing? Mr. Sarts? That's Benito Valles.
Good morning, Your Honor. Yeah, Mr. Valles has been assisting in running things.
Okay, did we do Fadley? No?
She just showed up. She was going with the kids until.
Oh, that's
Jared's-
what I thought.
Jared's
Okay.
talking to her right
Sounds
now.
good.
It might, who knows what's gonna happen, so.
Sounds good. So we're gonna run Dallas. We ready to do that?
I am, Your Honor.
Let's do it.
Yes, Your Honor.
How come I have an extra file here? John Kane. Whose file is this?
Oh.
Yes, Your Honor.
Mr. Sarge.
I requested an opportunity to talk to you in chambers with Mr. Ring and Mr. Kane.
Oh, okay, we can do that. I'm sorry? Yes, please. Oh, Mr. El Rambo. Oh, the motion. We're on the record in the matter of the people of the state of Michigan versus Madeline Grace Bailey, file number 23-00924 FY. Council appearance?
Brian Ring on behalf of the people.
Morning, Your Honor, Jared Austin, appearing on behalf of Ms. Bailey. She is present to my left.
Thank you. How are you, Miss Bailey? Okay. These your children? Okay. Today's the date, time set for the preliminary examination. Did you bring anybody with you to assist your children? Well, ma'am, you're gonna need to get somebody to help you with these kids so that you can proceed with the court case. Do you recognize that? Okay. What I'm gonna do is advise you that you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned in this matter, it looks like on March 21st. I am going to find good cause to go beyond the 21-day timeline because I want you to find some childcare or at least get someone that can come to court with you and sit with your children so that you can meaningfully assist in your defense, okay? It'll be May 25th and 10. I set it for May 25th at 10 o'clock, okay? Do you have any questions today, ma'am? Okay, we'll get you a notice to appear. Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further about Ms. Bailey, Your Honor. Thank you.
Thank you, you're all set.
Thank you, Judge.
No problem.
Bye-bye.
Bye. Maybe the kids can assist in that. Okay. On the record.
Maybe they'll help Mr. Edwards from this morning. He wanted
I
to-
know. On the record in the matter, the people of the state of Michigan versus Benito Vallis, file number 23-00889, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jacob Sargent, Fourth Assistant Public Defender here on behalf of Benito Vallis. He's present. He's at council table. He's seated to my right, Your Honor.
How are you, Mr. Vallis?
Good, how are you?
I'm doing well. Today was the date and the time set for preliminary examination. Are we ready to proceed?
People are ready to proceed at this time, Your Honor.
The defense would just request a standard sequestration order, Your Honor. Thank you.
Thank you. How many witnesses are you calling?
One, Judge.
Okay. You can proceed with counsel. Or you can proceed to call your first witness.
Thank you. This time people will call Officer Morgan Schaefer.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. So you can have a seat. You can state your first and last name and spell them both.
Officer Morgan Schaefer, MORGAN SCHAFER.
Proceed, counsel.
Thank you, Your Honor. Officer Schaefer, where do you work?
Lansing Creek,
How long have you worked there?
about 5 years.
In what capacity?
I am a road control officer.
And on January 10th, 2023, were you at around 6 PM, were you working in that capacity?
Yes,
And were you driving on Karen Street?
yes,
Was that in
correct,
Ingham County, Michigan?
correct.
And what did you observe when you were driving?
I observed several people outside of their house on both sides of the street. And in the middle of the roadway, I observed a Pontiac G6 in the middle of the roadway.
And did it appear that there had been an accident?
Yes, several. There was several trash cans. I believe there was the front bumper of a silver vehicle.
Did you make contact with the driver of that vehicle?
Yes, I did.
Who was driving that vehicle?
The driver identified as Benito Valles.
And is that person sitting in this courtroom today?
Yes, sir.
Can the defendant remove his mask for identification purposes?
Yes.
Can you please point to him and describe something he's wearing?
Mr. Benito is sitting here in the courtroom wearing blue jumpsuit and glasses.
Would the record reflect the defendant, the witness has identified the defendant?
No objection, Your Honor.
So noted.
And did you speak with the defendant?
Yes, I.
What did you notice when you were speaking with the defendant?
When I spoke with him, I smelled a heavy odor of intoxicants. He had slurred speech, had difficulty forming sentences, had red watery eyes.
Did you observe anything else in the vehicle at that time?
There was a passenger in the vehicle. I also observed what appeared to be a pint bottle of alcohol liquor.
And did you place the defendant under arrest? Where did you take him after that? Or what happened while you were placing him under arrest?
Your Honor, I think we're kind of getting into a little bit of these leading questions here at this point. I understand why they're necessary for foundational purposes, but I would object to starting it as we think.
Is that as to what happened during the arrest, or the direct, or the leading question about whether or not he was arrested?
Whether or not he was arrested.
Oh, I'll allow that question. You can continue.
What happened while you're attempting to place him under arrest?
He was placed under arrest, and while we were attempting to assist him to my patrol vehicle, he became uncooperative. At one point, he began spitting and refused to place his legs into my chauffeur.
And you said he was spitting. Was he spitting at you?
That's correct.
And where did you take him after that?
He was transported to Sparrow Hospital, both for medical clearance and for a legal blood draw upon search warrant being completed.
And did you observe anything at Sparrow?
He again became uncooperative, resisting verbal commands by both officers, hospital staff, and staff there. Again, he was spitting, being combative.
No further questions. I'm good. Thank you.
Cross-examination.
Thank you, Your Honor. Just briefly, how did you identify Mr. Valles at that location?
He was in the driver's seat of the vehicle.
Okay.
I used his identification card.
Okay, so you were able to obtain his ID.
That's correct.
And where was the vehicle located?
It was in the middle of the roadway on Karen Street. I believe it was just east of Sylvester.
And what were the lighting conditions at that time?
I'm sorry, the what?
The lighting conditions?
The lighting conditions.
Right.
It was dark outside with street lamps.
And you said there was another person in the vehicle?
That's correct.
Do you recall that person's name?
I don't. It would be another officer identified.
Okay, was there any sort of console in between the two? What was the layout inside the vehicle? In terms of the passenger seat versus the driver's seat?
I don't know what that means.
Okay.
passenger in the driver's seat.
What type of vehicle was it?
It was a Pontiac G6.
Okay. And was there a center console, some type between the driver's seat and the passenger seat? Could you recall what the inside of the vehicle looked like at that point when you first approached?
Like a car.
Okay.
I mean, I'm sorry. I think they're all pretty similar.
Okay. And when you first approached, did Mr. Bowers, were you in a uniform at that time?
Yes, I was.
Okay. And were the lights on in the vehicle? Was there anything else in the vehicle?
Yes, there were lights on.
Okay.
And music.
Lights and music. And did you shine your flashlight? Do you have a flashlight on you?
I did have a flashlight on.
Okay.
That's correct.
Did you shine your flashlight in the eyes of Mr. Valdez or the other passenger?
I don't recall.
Okay. And was Mr. Valdez awake when you first approached?
Negative.
He was asleep?
That's correct.
Okay. And what was his physical condition when you first approached? Did he appear to have any injuries?
Not a medical professional, but you're not here to have any injuries I can recall.
Okay. Where was his head located? Was it against the steering wheel? Was it
Just down, looking down. if I recall correctly.
just down? Okay. And was there any obvious damage to the vehicle, front end or anything along those lines?
Yes, there was obvious damage to the vehicle.
Okay, where was that damage?
I believe it was to the front end.
To the front end? Did you observe any air tags that might have been deployed or anything along those lines?
I don't believe that either.
Okay. And you said that Mr. Valdez appeared to be impaired at the time, correct?
Based on my knowledge of the situation, yes.
Okay.
The odor of intoxicants, what I view from his eyes and his slurred speech, yes.
Where in the vehicle was the bottle of vodka located?
It was on the passenger side.
Is in the passenger side? Okay. Did the passenger also appear to be intoxicated?
Correct.
Okay. But you did not find any intoxicants underneath Mr. Valdez or right next to Mr. Valdez, correct? Okay. When you observed Mr. Valdez, did you see any injuries to his forehead at all? Any injuries to his face? Anything along those lines?
I don't recall.
Okay. And when you first approached him, he was very agitated. How would you describe his mood when you first approached him?
Well, when I first approached him, he was slumped over in the driver's seat. And then he had difficulty forming sentences. And then he became uncooperative at some point during the arrest and transporting him to the back of my patrol vehicle.
Okay. How did you roust him from being asleep at the time? Was there any smelling salts used or
Was there any what?
smelling salts used? What technique did he use?
Smelling salts?
Yeah. You said he was asleep at the time, correct?
We don't use smelling salts.
Okay.
So no smelling salts. I just use verbal commands to wake him up at that time.
Okay. Just verbal
I
commands.
asked him to take the keys out of the ignition, and then I asked him to step out of the vehicle, at which time he did.
Okay. So initially he was responsive and was complying with your orders. Okay. So, but you said at some point he stopped following those commands?
That's correct. At some point, from him exiting the vehicle, being placed in handcuffs, and then me transporting him, meaning me walking him, assisting him to my patrol vehicle, he started becoming uncooperative at that point.
Okay. And was he responsive to you when you were giving him commands?
No.
He was not responsive.
After exiting the vehicle, again, he became unresponsive at one point between putting him in handcuffs and then me assisting him, walking him to my patrol vehicle.
Okay. Just one second.
when you first approached, did you see? This was would you describe this as like a four-person passenger vehicle? Was there a back seat?
Yeah, I believe it was.
Okay. Did you see a third person at all?
No.
Okay. Was there anything in the back seat? Well, did you look at the back seat?
I don't recall what was in the back seat. No.
Okay. Did you observe maybe a door open on the back seat side of things? One of the other passenger doors open?
I did not.
Were any of the doors open when you first approached that you could observe?
No, not that I observed, no.
Okay. No further questions, Your Honor. Thank you.
Briefly, Your Honor. Were you able to read the defendant a copy of his chemical rights?
I was not able to read him a copy of his.
Why not?
It was uncooperative, talking over me.
And while you were at Sparrow, I believe you said he was spitting at Sparrow.
That's correct.
Was he spitting on any other officers?
I don't recall. If so, they would have written out something else.
Thank you. No further questions this time, Your Honor.
I need more clarification as to what uncooperative means.
Uncooperative, I'm sorry.
What does you mean when you say he was being uncooperative? What was he doing?
Flailing his arms. While we were at the hospital, he was laying on the cot and he refused to sit there and lay down. He was getting up, trying to kick and use his arms that were placed behind his back.
Okay, and you gave him verbal commands to stop that?
Yeah.
Okay.
Both myself, hospital staff.
All right. Was he spitting at you or?
I was behind the cot at that point. There were two other officers there and then several security staff.
Okay, so he was just spitting in general?
Yep, he was spitting in general.
Got it.
I believe it was at the other security staff
Okay.
officers.
So
But not me personally.
Oh, you believe he was spitting at another officer or a security officer, but not like spitting up kind of thing?
Yeah, no, it was a deliberate. spit,
Okay, got
not an accidental.
Can we cross-examine or redirect based on that?
I do have one brief redirect based off of that. Did he spit at you at any time personally?
When we were putting him in the back of the patrol vehicle, he spit at that point as well.
Was that a deliberate spit?
It was a deliberate.
Thank you. No further questions, Your Honor.
No further questions, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor.
Thank you, Officer Schaefer.
Thank you.
Call any other witnesses?
People have no further witnesses. People do have one exhibit to introduce into evidence under MCL 766.11B, and that's just the lab report. I did not get it marked ahead of time. That would be people's proposed one.
Your Honor, just for preservation purposes, I'll object to lack of foundational grounds. Thank you.
I don't even know that it's even needed for the count that's a felony, but.
I don't think it is needed, Judge, but I did inform Mr. Sartz that I was planning on amending the count to a high BAC.
Oh,
So I just
gotcha.
wanted it in the record for that purposes.
Makes sense. Okay, for the purposes of the exam, People's Exhibit 1 is admitted. Any defense witnesses?
No witnesses at this time, Your Honor. Thank you.
Okay. You can proceed to argument.
Thank you, Your Honor. We heard testimony from Officer Schaefer, who responded to Karen Street, which is in the city of Lansing in Union County, Michigan. She identified the defendant was the driver that she saw in the vehicle. She was in uniform. There were lights. She was giving him lawful commands to step out of the vehicle. He did begin to comply with those commands and got out of the vehicle. At that point, when she began to place him under arrest, he'd become uncooperative, flailing his arms around. When she was trying to get him into the vehicle, he spit at her. Your Honor. And then again, once they got to Sparrow, he again became uncooperative, began flailing around, began resisting, and began spitting at anybody in sight, Your Honor. So this time, Your Honor, we would ask that the court bind this over on all counts. Thank you.
Okay, you're amending count three.
Yes, Your Honor, and we would amend, was that count three? We've been amending count three, operating while intoxicated, to operating intoxicated with a high BAC.
Mr. Searles?
Thank you, Your Honor. Respectfully, the defense would object to the pressure bind over here. The people have not necessarily proof. Respectfully, the story was it's not credible enough to warrant bind over at this time. So many inconsistencies with the narrative that does not match up with the elements to the charge. So respectfully, the defense would request that this count be dismissed. Thank you.
Can you, just for the court record, highlight what some of those inconsistencies are?
Well, Your Honor, I think respectfully, the officer did not describe the sequence in terms of when she gave an order and how Mr. Valles would have responded to that would qualify as resisting. Respectfully, she did make it clear that Mr. Valles did at least initially comply with some of the orders, but there were some inconsistencies in my view as related to when she was issuing the orders and what Mr. Valles' responses were. Further, Your Honor, there was certainly a possibility that, and this is what ultimately be a question of fact for a jury regarding Mr. Valles' state of mind at the time, given this type of charge, which that certainly does require an element of intent, Your Honor. So for those reasons, respectfully, I would request that the case be dismissed.
Thank you. Today's the date and time set for a preliminary examination. At the time of preliminary examination, the burden is squarely upon the prosecution to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you as a defendant with the crime. This is not a burden that should be compared to what they would need to prove beyond at the time of trial, which is to prove each element beyond a reasonable doubt. This is a relatively low burden of proof here, and the burden is flexible, and it's more than mere suspicion that a crime was committed is what we are looking for at this time. And the court is the sole determiner of credibility of the witnesses. We had a testimony here from one witness, that's Officer Morgan Schaefer from Lansing Police Department. She testified that on January 10, 2023, at the area of Karen Street at or near Sylvester, City of Lansing, Ingham County, State of Michigan, she responded to an incident. She observed several people outside, and there was a Pontiac G6 that was in the middle of the street. It had or would appear to be front end damage. She said, based on the display, it was apparent to her that an accident had occurred. There was a front bumper damage, trash cans that had fallen over. She made contact with the individual that she identified in court today as the defendant, Benito Lorenzo Valles, and that she stated she could smell intoxicants from him, that his speech was slurred, that he was unable to finish his sentences, and he had red, watery eyes. She also located a pint bottle of alcohol in the vehicle. She described her interaction with the defendant to be uncooperative at certain points during the interaction. She did testify that she took him into custody, and that sounded like it took place without any major resistance. She did testify, though, on redirect that he did spit at her during that time, that he was then transferred to Sparrow Hospital, that he was uncooperative, that he was resisted or opposed the commands when he was supposed to be laying on the cot. He was flailing his arms and attempting to spit at the officers and the security and or hospital staff. And that his blood was drawn during that time. People have admitted People's Exhibit 1, which is from the Michigan State Police Forensic Science Division, indicating lab report results of 0.194 grams of alcohol per 100 milliliters of blood. Count 1 in this complaint is police officer assaulting, resisting, obstructing And to prove this at trial, the people would then need to prove beyond a reasonable doubt first that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered an officer who was a police officer of the Lansing Police Department. That the defendant actually knew was a police officer and performing her duties at the time. And third, that the defendant, I'm sorry, that the officer gave the defendant a lawful command and was making a lawful arrest or was otherwise performing a lawful act. The testimony here was that the defendant became uncooperative and failed to adhere to the command. I think I specifically asked her to describe in further detail what she meant by being uncooperative, and she stated that he was supposed to be laying on the cot. He was flailing his arms and kicking and attempting to get up. And I asked her myself, did she give him a lawful command? She indicated that she did, and he was supposed to be laying and being cooperative during his time at the hospital. There's also testimony about what the court would perceive to be as an assault, and that he attempted and or did spit at the officer while being transported, and then there were some attempts or some spitting that took place according to the testimony at the time that he was at Sparrow Hospital. So as to count one, the court believed that there is sufficient probable cause to bind over to the circuit court that will be bound over for further prosecution. Count two of assault and battery will be bound over to a company. That's a misdemeanor. People are asking to amend count three to a high BAC based on the blood alcohol content that will be amended to operating with a high blood alcohol content. This file will have a bind over date of April 19th. You do not need to appear in court on April 19th. That's the date the circuit court will get the file from this court. Your next court date, sir, will be a pretrial in the circuit court. Both you and Mr. Starks will be made aware of that court date, okay?
Yes, ma'am.
Do you have any questions at this time?
Oh, ma'am.
Bond was set at 1,010%. That will continue. Any additional matters for the record?
Nothing bad, people. Thank you.
And just to request the transcripts, Your Honor. Thank you.
Just can I grab my exhibit?
Yes, please.
Thank you.
Nothing to give you too much.
No, there was
Oh,
a second
okay.
page.